This past June, the Supreme Court released a decision overturning the Chevron Deference decision, unraveling 40 years of policy. The Chevron Deference, named after a 1984 Supreme Court ruling, essentially establishes that when Congress passes an ambiguous law, courts must defer to an agency's reasonable interpretation of that law. In other words, when laws from Congress are vague, it's agencies and agency experts who can make decisions, not the courts. The Chevron deference was built on the idea that scientists and other specialists at the agencies have more expertise than judges in determining regulations. It also comes from the idea that the executive branch, which appoints those in the federal agencies, is more accountable to voters compared to the judicial system. Many of our everyday activities, such as flying on planes, driving cars, even just going outside for fresh air, are regulated by these agency experts. This decision could mean that more of those regulations can be struck down by courts, who will now be given more power to interpret statutes. This has profound consequences on the environment and EPA regulations. More broadly, environmentalists fear that with the Chevron deference gone, carbon emissions cutting legislation will be moot. In fact, many of these rules are already being targeted by lawsuits. What will this mean for open data practices in general? With the new SCOTUS decision giving the courts the final say on regulations, legislation like the Clean Air Act or the Clean Water Act might be implemented in different contexts. For one, it will be much harder to create a national consensus on open data policies. The EPA has always been like a North Star for data reporting policies because what the EPA says sets the minimum standard for data collection and filters down to every state. With this decision, state and local agencies will need to better regulate air data access and sharing policies. This can create a key problem of differences between states. For example, California has much stronger open data policies than the federal government, allowing for conversations with agencies about improving reporting policies. But what about the states with more lax regulatory environments, such as Louisiana? We might see the rise of some sort of patchwork nation, where different states have incredibly varying regulations. Now, it'll be up to cities or communities to fill in that gap. So, what can we do? We need to keep sharing our research and data as openly and as safely as possible, while finding legal avenues back to accountability. The Supreme Court's decisions oftentimes will be applied differently in various contexts, but everywhere, people will continue working on local community science efforts or forming environmental affinity networks like the Beyond Compliance Network. Join these efforts to meet with other like-minded people who are going to continue advocating for more and better open environmental data practices. How else are open data practices going to change for you? What can we do to ensure data is still easily accessible?